Welcome back to another edition of Between Two FARS. I'm Warneke Miller here once again with the legendary Robert Tepfer. Bob has had a 22-year contract law experience with the Air Force before joining NASA almost 22 years ago now, right, Bob? And
24.
Yeah, a total of 44 years in federal contract work and a vast experience with litigation. And we're also joined by the illustrious Dave Schuman, who has just come off a 5-year debacle in front of the ASBCA, and he himself has 31 years of experience at NASA. We have got a real power duo here today, and they're going to talk to you about a very serious subject. The best litigation is no litigation. Gentlemen, what does that phrase mean to you?
Well, we always used to say smart lawyer stays out of court because you can't control it, is one thing, but the other thing is the use of resources. And to a large extent, folks in the organization involved have no appreciation of what all is going to do to them. If it's one of those marriage contracts that goes on forever, all of a sudden folks that had some kind of collegial relationship are getting deposed back and forth, or they're at a minimum paying for depositions, they're paying for all sorts of discovery. A lot of times they think the discovery belongs to the lawyers that will go through the documents, when in fact they're the only ones that have the full appreciation. So a large part of the case, I'd say about 80% of it, belongs to them, their resources. They don't understand that at the inception, and they feel like, well, you know, if we can't get along, by God, you're going to deal with our lawyers. And then when you have to explain to them, oh, we'll do it, but you're going to be there all along. That's one thing. And the other thing is the cost associated with it, the travel, the paying for court reporters, all those issues. The logistics of doing the litigation is extremely expensive, very time consuming. And you know what? You're not guaranteed a result. And that's...
Yeah, Dave, how about you? What is the best litigation is no litigation? What does that phrase mean to you?
Yeah, so to echo what Bob has said, and to say on the record, thank you to both of you for organizing this. You know, having been through a long experience where we spent a lot of agency resources, time for the lawyers and for the clients, like Bob said, tremendous amount of time for the clients, really 24/7 in the 6 months leading up to litigation. I feel pretty strongly, as does Bob, that the most efficient use of the NASA legal resource is proactive to avoid litigation in the first place. In particular, I'm a big supporter of training and staying on top of contracting officers and their management to make sure the contract is administered correctly. In our case, because it wasn't administered correctly twice, we had a 5-year litigation and very intensive trial, which absorbed me as a legal resource from my office full time for 1.5 years. And that's a huge drain on the office. As Bob said, it's a huge drain on the clients, and they didn't expect it, but they had to work really 24/7 in the later stages, and this was very difficult for their own environment, for their management to explain. As Bob said, it's not our case. Yes, we do the litigation part, but it's the client's case, and they have the bulk of the work. So it's much more efficient to try to avoid having that litigation where you're in trial really at all costs, if possible.
What are your thoughts, gentlemen, on settlement once a piece of litigation is initiated, whether it's by NASA or by NASA's contractor? What should clients be thinking about just generally on the concept of settlement?
Well, when you're dealing with the cost associated with whether or not it be travel, depositions, and the personnel involved, it becomes almost like a business judgment. Are you willing to spend this kind of money and you're not getting a guaranteed result? We cannot promise you that result because realistically, again, going back to the issue of actually being in litigation, if it was so obvious that you're going to win, you wouldn't be there. You would have had a settlement. And a lot of folks don't understand that because TV corrupts their logic, and they want to effectively show that contractor when in fact, the contractor must have some kind of a case, or their counsel would effectively back off a little bit. Or in that point where you could reach that point is kind of where you ought to settle. The only problem that we ever had was that we're a sunk cost. So a lot of times they just say, go for it, and they go forever independent of any logic.
Hey, what are your thoughts on settlement?
Yeah, just to echo that, it's a mistake for the client to think, well, we'll just send the lawyers in, they'll do the fighting for us and take care of any messes and clean it up. So, settlement is certainly appropriate at any time, even up till the point where the board issues a decision. We did try that in my case in particular when we were quite desperate, not having resources to do the trial, and we were headed to trial. Unfortunately, the settlement discussions were not successful. So, of course, it takes two parties. But the most important thing I would say as an overview with respect to the settlement or the litigation is extremely important to have management and the clients and the lawyers on the same page as to what the course is. Because if they are not, that's going to lead to difficulties in defending the case. So we had some very good training, Bob, from the Air Force ASPCA litigation team a couple years back now, and they recommended doing a memo to management at some point during the case, and I did do one, but it was really not even comprehensive enough. I think in retrospect, in addition to the potential liability and the cost to defend the case through trial, it's very necessary to explain in excruciating detail how painful this is going to be in terms of time and resources for the clients and for, in part, for our management. To have a lawyer be gone from the office for 2 years is very painful, and to have, my client was in the range operations section at Wallops Flight Facility and involved in national security launches, and he was out of commission and caused him a great deal of difficulty in that position. He wound up taking another position after the case was over, just because management didn't see the merit in him participating in all this work, which is outside their organization. But there it is. So, I would be very explicit about that, 5 to 10 page memo explaining this in detail, and have management sign it on the dotted line, signed and dated. You can do more than one of those, do one at the beginning and do one when it looks like you're really headed to trial, and just make sure everyone's in agreement as to what's involved. And that will, I think, make people look with a very sharp eye at the path forward. But everybody has to be on the same page on that.
Yes, some very valuable insight right from the trenches. You do need to, as Bob likes to say, parade the horribles. It is our responsibility as attorneys to let management know, let the decision makers understand what they're getting into if they choose to proceed with litigation. But there's always the opportunity for settlement. And as we said at the beginning, the best litigation is no litigation. We'll see you again next time between two FARS.